Good evening. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law. I want to welcome everybody who is joining us on tonight's webinar. I also want to introduce our co-host, Jane Faherty. And we have a special guest, or one of our returning champions, as I like to say, Allie Grafman, who's an educational consultant and special education advocate. We've been having a series of webinars, finding your voice as parents, taking ownership of your child's education in these challenging times brought on by this, what appears to be a never-ending pandemic. We are continuing to present our Zoom webinars because we are part of a community of concerned parents and professionals still learning how to connect in order to get through these difficult times. And as we've all seen in the recent weeks, we now have another spike with the COVID-19 numbers and the implications for our children and parents of children in school settings. We've been moderating a series of webinars for the past year or so to try to address needs that impact a child's special education journey. We've convened tonight to address questions more in a roundtable format with Allie Grafman, Jane, and myself. Before we begin, I always start with a couple of disclaimers. One, we are in the state of Connecticut. We have people from other states and I understand countries as well joining us, but most of our information, unless it's the federal law, is specific to the state of Connecticut. This webinar is being recorded. The information provided during tonight's webinar does not constitute specific legal advice to you or your child's circumstances and should not be relied upon as such. The webinar does not create an attorney-client relationship with attorney Lawrence Berliner, myself. It doesn't create a professional relationship with Allie Grafman or Jane Faherty as well in their capacity as co-hosts, advocates, and consultants. By signing up, you've agreed to receive information about future webinars and events from the Stamford Jewish Community Center and the Law Office of Lawrence Berliner. Please note that Zoom is a third-party provider and is not an agent or associated with the Stamford Jewish Community Center, the Law Office of Lawrence Berliner, or Allie Grafman. We encourage questions. We have a series of questions that we have received prior to tonight's webinar. We prefer that the questions be general in nature. And that you use the Q&A format at the bottom of your computer screen and not the chat format. The reason being is the chat is recorded, but your questions are not. And in order to maintain your privacy and confidentiality, we prefer that you use the Q&A format. For those who've been following us over the years, you will probably have seen Allie Grafman join us at least on a couple of occasions that I can recall, and very pleased to have Jane join us each and every month that we have these webinars. So have Jane introduce herself and then have Allie introduce herself, and we can discuss what's new since last year. Literally, our last webinar was in December, and get to some of the questions and concerns that have been pressing since our last webinar.
Hi, thank you so much, and hi Allie, it's nice to see you again this year. So I'm Jane. I am the director of a program called JumpStart, which is located in the Stamford JCC. That's one of the hats I wear. The JumpStart program is for children typically aged between 2 and 3 with developmental delays. And we provide a one-to-one toddler preschool experience, working on the individual needs of those children who are typically referred to us from birth to 3 clinicians and providers or pediatricians or people within the local community. I also help those children transition into the public school on or around their third birthday and attend those PPT meetings and continue to advocate for them as they go through elementary school. And I have some friends that I continue to advocate for up into middle school. In addition to that, I also do lots of collaboration with different organizations within the community on behalf of a foundation, organizations such as STAR, Ableist, Mill River Park, and some different ventures. So I enjoy the multiple hats that I wear, and I'm happy to be back again this year. I might have a cough at times, so I do apologize in advance if I have to mute myself and I'm looking as if I'm choking. I have some throat lozenges here to help out. But it's great to be back. There's been a lot that's been happening in a short space of time with COVID and the impact that has had upon even my own classroom. These last 2 weeks we have gone remote because of staff shortages, with majority of my staff actually having COVID at different times and fulfilling our JCC quarantine guidelines. But we have managed to provide online remote instruction and have seen the children engaged and having fun with their parents. So it's been an interesting start to the year, but hopefully looking forward to next week having the children back in the classroom again. So Allie, it's lovely to have you here again with us this year.
Thank you, Jane, for the introduction, and welcome everybody, and thank you for participating. If you're from Connecticut with this frigid cold night, I hope you're sitting by a warm fireplace because it is rather chilly out there. So to introduce myself, my name is Allie Grafman, and I have an advocacy company called ABC Advocacy LLC. The ABC stands for Advocacy Brings Change. And that is my motto. I fully believe that with collaborating with parents and families, as well as schools, we can all benefit the child that we are working with. And the change is usually a positive change. So my background is varied. I started as a young adult in public education as a special education teacher, and then went into administration and became an administrator in a public school in special education. I was a coordinator and interim director. And so I have that perspective of the school and how to navigate some of those narrow and difficult pathways that I'm sure many of you have already been involved with. So I do have that perspective, but I also, as an advocate, feel very strongly that students' needs need to be met. So that's what we're all working for. We're all working for the benefit of the child, of the student. There's no sides to be taken. It's all about the child. So I'm glad to be here tonight, and we're ready to answer your questions and to proceed with the webinar. Thank you.
Before we begin, I just want to point out that what's in the chat room is the contact information for Allie, myself, and Jane. We always get this question, how do we get a copy of the recording? If you've registered for the webinar, you will receive a copy courtesy of my daughter, Rachel Berliner, who's in effect the moderator. So we will provide that. And I did see there was one question about somebody from West Virginia, how to get an attorney in West Virginia. Before we get to the other questions, I would contact Disability Rights West Virginia, which is the protection and advocacy agency in West Virginia. I don't have the contact information, but each state has a protection and advocacy office, and most of them start with disability rights - their state. The other possibility, there is an organization that I am a member of. I don't know if Jane or Allie are, they can let us know, called the Council of Parents, Attorneys, and Advocates, otherwise known as COPA, C-O-P-A-A. Go on their website, and they have a section on how to find attorneys and advocates and others who are members of COPA that are state specific. And those would be two starting points to answer that question.
Just quickly with regard to COPA, I am a member of COPA and I completed their SEEK 2 training, which was wonderful. They are a great resource for parents to go on and look at too, particularly if you do live in a different state. But they're just a good resource generally. They have some up-to-date information that might be happening on a federal level that they often post and update with. But they're a good organization to connect with other parents too in your local area as well, that you might find that you've got similar things that you're contending with. So as Larry said, COPA is a good resource.
So I think it was Jane said a lot has been happening since our last webinar. What's new? What's going on? What's been changing in this 11th day of a brand new year?
Well, one of the things that did happen on January the 5th, the state of Connecticut Department of Education did release a memorandum just to remind everybody of the requirements of the IDEA, which is it had been brought to their attention that some districts had failed to provide triannual evaluations for students and or not completed or provided annual PPT meetings for some of the students. There were various reasons as to why these might have been oversights by the districts, but what was nice is that it was made very clear and a reminder to all the directors of special education and public services that students and their parents are entitled to these triannual and annual reviews. And this document can be accessed. Larry, are the contact information for this document in the chat?
The January 5th memo and the link is posted on the chat section.
But I think it's a good reminder for parents to remind themselves that these are important dates to put on their calendars, and that while a district might fail to remember a triannual or an annual PPT meeting, there is nothing preventing you as an important member of the PPT team to request and remind the district of the dates that might be pending on coming up that year. So you can book those PPT meetings well in advance, and in regard to evaluations, make sure that they're done on a timely basis and that that information is given to you before the meeting, so you have a chance to review it ahead of time and digest it and understand it. But I thought it was good that the state acknowledged that there have been lapses within districts, and they were reminding all involved that this is not in compliance with the federal guidelines and your rights as a parent, and obviously your child's rights. It's very important information that needs to be reviewed on a regular basis.
And the goal of the State Department of Education is not to have an IEP that's more than 365 days old. And I have had this experience, I don't know if Allie or Jane have, where the schools realize the IEP is about to expire and they ask permission to extend the IEP until the current IEP until the next PPT date, so they can satisfy the compliance issues with the State Department of Education and then do what they're supposed to, timely complete the evaluations and timely schedule the annual review PPT meeting. So I've had several of those situations where the schools have forgotten about the annual review. And I might add, it's on the front page of the IEP when the annual review is due. We did have a question also on the chat. How long does it take to do complete evaluations? If this is an initial evaluation, the State Department of Education has a 45 school day timeline for initial evaluations from the date a parent gives the school district their written consent for an evaluation. If this is other than an initial evaluation, there's no prescribed timeline, but the word reasonable sometimes shows up. So if you're planning a triennial evaluation, it's always a good idea to know what the expected date that the triennial evaluation will be completed. If it's an initial evaluation, it's 45 school days from the date consent is provided, and the next PPT meeting has to be convened on or before that 45th day.
Because every child is different, and children that I have worked with, sometimes the methodology or the tool the evaluation tool a district is going to use isn't really suitable for that child. But until they try, they don't know. So you do want to allow enough time for the district to use the right tool. And in some instances, children need a longer period of time to be correctly evaluated in the right way. So it is important to have a timely communication about when that training is going to take place and the evaluations that are going to occur in that triennial, and give them enough flexibility to use the different methodologies. But some children will need longer to be evaluated than other children. So that's really important to remember when it comes to evaluations, that every child is different and that they need to factor that into their timeline when completing.
I wanted to add that sometimes if the PPT as well as the parents, give consent for an out of district evaluation, that may be just cause to extend the evaluation period time with it, it has to be in writing. The parents or guardians may agree to that because of the extenuating circumstances. Out of district experts in the field oftentimes have timelines that exceed that 45-day school day maximum. So there is some flexibility, but they are on for specific reasons. That's
we have a question. What's the difference between an educational consultant and an educational lawyer? I can answer half of that question. Do either you want to answer the other half?
I'm an educational consultant. I have my master's in early childhood with special needs. It's one of the qualifications I have. I have other qualifications. I'm also SEEK 2 COPA advocate certified. There is no official certification for advocacy in the state of Connecticut that is required, but I have completed that training. So I do consider myself an educational consultant because I do practice, I work with children, I tutor privately, I advocate, and I get involved in lots of educational projects within the JCC and actually within different community programs. So I consider myself an educational consultant. I am not an attorney. I have not been to a law school or passed any legal exams, just COPA exams with regard to advocacy. How about you, Allie?
So I'll just add to that, Jane. You said quite a bit, and I agree with everything. There is no certification for a consultant or an advocate. We're going to interchange those two words. However, that being said, many educational consultants and or advocates have certification in certain areas. They, it could be a school psychology. In my case, I have an educator's degree as well as an administrative degree. So if you are looking for an educational advocate or consultant, you would want to know their background and experience. So that's one thing. The other I guess addition to that is I, as an advocate, will never give advice, legal advice. Okay, so it's a supportive role, but it is not a legal role. Anytime that, and I have done this many times, Attorney Berliner can attest to this, that if I feel that it is out of the scope, out of the limits of an advocate or an educational consultant, I will always refer or defer to a special education attorney. So there is a difference. There's also some overlap. And we both can go to PPT meetings. We can both prepare clients for their own PPT meeting. There's many avenues that we do overlap, but the biggest difference is that legal framework that advocates and consultants do not engage in.
Allie and I would not attend a due process hearing, for example. That is something that Larry can talk about. What's the difference, Larry? What do you do versus us?
Well, as Allie and Jane pointed out, there are overlaps between what I do as an attorney and what they do as consultants or advocates, but there is a point of demarcation. I'm a licensed attorney. I've gone to law school. I have had extensive training in the field of special education law and constitutional law and other laws that apply to special education. I do litigate. I do go to due process hearings. I go to state and federal court. I have a code of professional ethics. As I mentioned, I'm licensed. There are standards for lawyers that have to adhere to be admitted to practice in both the state and federal courts. One of the major differences, I don't have a degree in education. I was not a special education teacher or administrator. And what I often find, and you have two examples tonight, that often people who are advocates have more educational background, certifications, school psychology, education degrees, and lawyers tend not to. I rely heavily on advocates to get into the development of goals and objectives, the language of the goals and objectives, because they bring to the PPT meeting a much different perspective and experience. It's sort of when the wheels go off the tracks, that's when I get involved. So when the parents and their advocates and consultants are attempting to get certain services into an IEP, those requests are denied. That sets this up for a review of procedural safeguards. The procedural safeguards are the students' and parents' rights in the field of special education. One of those rights is a due process hearing, that if you disagree with the results of a PPT meeting, a parent can request a due process hearing. Another right is a request for an independent evaluation, and I always advise parents to be prepared to consult with an attorney when they ask for an independent evaluation to be paid for by the school district, because if that request is denied, a school district will most likely file a request for a due process hearing against the parents to defend their evaluation. So I work in tandem with advocates, and advocates often work in tandem with me. And we work collaboratively. There is an overlap with what Jane and I do and Allie and I do. However, there are differences, and one of that major differences is when we get ready for litigation. We try very hard to avoid litigation, but there are cases that do go forward.
Just a quick side note, I do actually participate in custodial situations as an expert witness in court. So I have done that a number of times for private clients, where I work with the family and the parents and help provide educational insight in terms of the child that might be in a custodial situation. So I do attend court trials and hearings and work with attorneys as an educational expert, but that is different to the role I perform as an advocate within a district. But I have got involved with that in a number of instances.
In conjunction with that, Jane, an advocate and educational consultant can also attend with the family mediation, which is a voluntary process between the school district and the family. It is not a legal process. It is, as I said, a voluntary process. So advocates can attend mediations as well.
Yes, yeah. And just like you, Allie, as an advocate, part of our role has been to support families with out-of-district placements when they've been able to reach an agreement at a PPT and not have to go to due process and things like that too. But it's great to have people like Larry as part of the team that we can hand information over to if he needs to carry on that pattern for us and take it that step further.
We had some questions tonight, and one of the questions is your experience and advice for a family that wants to register their child with school and for special education. Any tips, advice?
My first port of call would be to go to the district website and register your child within that district website. The websites, typically the information can be uploaded online now, so they might require a birth certificate. They might require some proof of residency. You typically can't register a child in a district until you actually have proof of residency within that district. However, if you know that you are moving to a district in advance, I would always recommend that you reach out to that district, maybe to the school principal, if you know which school your child will be attending, and or the director of services within that district. Introduce yourself, let them know who you are, your timeline when you're coming, provide them with as much information ahead of time as possible, and also try to schedule a PPT meeting to give them enough opportunity to review the information that you're presenting with regard to your child, so that together you can collaborate and put together a good IEP before that child joins the district. And that advice would be whether you are coming to a new school from a different state or coming to the school from a different country. The process, I think, would be very similar and the same. And it's all about developing that relationship and that communication with the district and with the team as soon as possible and as early as possible, and give them as much information as possible regarding your child. What do you think, Allie?
I think you summarized it pretty well, Jane. The only thing that I would suggest, and as a public school administrator, I did this quite frequently when the time was appropriate. I would meet with the families, and I would recommend that you try to have a meeting, a remote, most likely meeting, with whoever would be the administrator, either a school principal, director, sometimes coordinators for your particular child's school level, elementary, middle school, or high school, especially if your child has complex needs. And that would be very helpful for you to have a remote meeting prior to the PPT, so you can really set the groundwork. No decisions will be made at that meeting, but it's really an information seeking and sharing of information, what the school has to offer and what your child's needs are. So if that can be established and scheduled prior to a PPT, that would be very beneficial.
I think it's also nice to provide the human element and to share photos of your child and maybe a video of your child, so they can really see who that individual is, and they can start to connect and relate to your child beyond it just being another number within the district or another name that comes across their desk. So I highly recommend photos. Really helpful to help teams and individuals connect and relate to who your child is, or videos if you're comfortable, but everybody has different levels of comfort with regard to that.
Thank you. We have another question about compensatory services and reduction of services. The State Department of Education has a memo dated May 24, 2021 on compensatory services. All the state information, State of Connecticut Department of Education information is available on ct.gov. That's the state website. You open up the alphabet and letter E will be there. That's for all the E agencies. Click on Department of Education. You'll see a link to special education. And there are publications, policy guidance, memos that are on the State Department of Education website. As far as reduction of services, that's typically a PPT decision when services are added to an IEP, there should be an evaluation. When services are taken out of an IEP, there should be an evaluation. And if there is a consensus opinion to add or subtract information, that's good. And this is done by agreement. If there's a disagreement, then what will happen, you have your procedural safeguards. And that's where having an advocate or an attorney to go to a PPT meeting and exercise procedural safeguards regarding a disagreement come into play. For the person who asked for the contact information, it's in the chat room. We have just scrolled to the top of the chat, and the JumpStart, the ABC, Advocacy, and the Law Office of Lawrence Berliner contact information is on the top of the chat.
So Allie and Lawrence, a question we got was, how do I get the best education for my child? Now, this is a very broad question, and obviously that's what we are here to do as advocates and attorneys. What recommendation would you have for parents and also educators in terms of to get the best out of a child that maybe they're working with? We do sometimes get some professionals within districts watching this webinar. So any advice or suggestions there?
My feedback on that is parents can be and should be the best advocate for their own child. If you can advocate for your child, that would afford you the best education for your child. If you're on top of everything, be proactive, not wait for the school district to call a PPT when you see your child struggling or grades falling or child resistance to go to school. All of those red flag signs. Be proactive. As a parent or a guardian, meet with the teachers. The teachers are the front line. So, that's where we start, with the teacher, communication and collaboration. As Jane talked about, that human contact is really important. You want to build a relationship. It's not a confrontation. It's a bridging of family and school. That collaboration is really important. That's how we get the best education for our child. The school doesn't look necessarily at the child's education as the best. What they're saying is what is appropriate. What are the child's needs, and how are we providing for the child? So even though as parents, we all want the best, the school is not necessarily looking for, that they use the expression that the Cadillac versus the Ford. I know that's an old expression, but that's kind of what the school is looking at. So being on top of everything, going to PPTs, being prepared for that PPT. And we can talk a little bit, I know there's a question about how do we prepare for PPTs. There's many ways that we can, but having all the materials that you need prior to that PPT. So when you get there, you can listen with context, with knowing what the evaluation maybe is said, or what the students' current levels of functioning are. You already have that knowledge, so you can really focus and attend to that PPT and be alerted to anything that you feel that you disagree with. And if you disagree with something, you want to make sure that that is written on the IEP, that you disagree, because that's important documentation. So again, collaboration, establishing a relationship with the school, and keeping on top of everything, I think are probably the most beneficial ways to afford your child the best education that you can get.
I just want to add on to what Allie's saying. What I find, I am an educator. I've worked in classrooms as well as doing the other pieces that I do. That as parents, I always recommend, and as a parent myself, communicating with school districts, it's very good to have that verbal conversation with a teacher. However, it's really important, I think, to then follow up with bullet notes as to what you discussed. because sometimes in the moment, we assume the person has heard us. They might have nodded, they might have agreed, but it's nice to follow up with it in print and in writing. So you start to develop a paper trail, which you can then use as a timeline when you're putting together. You know, I did mention to you my concern with regard to my child's reading habit. I did mention to you that we were struggling at home with transitioning from home onto the school bus. I think it's very important to always have as much as possible. COVID makes it difficult, but as much verbal communication. But I would always recommend following that verbal up with a straightforward bullet note, following that, thanking them for the time, but just highlighting what you discussed. If there were actions that you'd agreed that you would take and that they would take, kind of summarizing it, does not have to be elaborate, just a one-page summary, thank them for the conversation, email it to them. Email is a very good way for you to keep your documents organized and in sync versus a handwritten note. There's value to handwritten notes, but I recommend if you ever do send a handwritten note, make sure you take a copy of it before you send it on, so you have that for your records too. So even if you think it's an incidental conversation where the teacher said, Johnny struggled a little bit in gym today, it might be worth following up with a little note. Thank you, Mrs. So-and-so, for letting me know that Johnny struggled in gym today. You noticed it was because of X, Y, and Z. If you start to collect this data and this documentation and keep a note of who you spoke to and when you spoke to them, it will help you build up a portfolio of progress or regression, or will help establish the communication and make sure that not only are you conversing and sharing information with them, but they're receiving it correctly and they're understanding what it is you're trying to impart and share. Because sometimes we say yes, 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 but we're really not listening or taking it in. And this is just another means by which to check and confirm and clarify. And some people are visual listeners, auditory learners, and some people are visual learners. So by doing hedging your bets, I would always recommend following up an incidental conversation with a note, just to clarify. Any other thoughts, Larry?
One more thought, Jane, that came to my mind when you were talking. I have families that when I work with them, they discuss the needs of their child. And I'll say, well, what about this particular service? Let's just say therapeutic horseback riding. Okay, and they go, what? I didn't know we can do that. I'm not saying that every district is going to offer that, but that's an example of services and ways that we can meet your child's needs through different resources. So what I'm saying to you is try to find out whether you network with other parents, other professionals, advocates, attorneys, consultants. Find out what resources are available, because many families don't even know what to ask for. And that's really important. If you don't know what to ask for, then you're not going to ask for it. So do the front work, find out what is out there that can really benefit, service your child. And that is, really laying the groundwork, I feel, for meeting your child's expectations and needs.
I just wanted to add to everything that Jane and Allie, by simply saying, unfortunately, what's best for a child's education is not what's appropriate. And it's not me speaking, it's how our federal courts have interpreted this law, the Individuals with Disabilities Education Act. But that should not prevent a parent from creating very high expectations for their child, because the low expectations will be achieved all by themselves, but it's the high expectations that require work. And we live in a very exciting age of the internet. And as Allie pointed out, if you don't know what to ask, Google it, do something. I'm sure there's a piece of information out there. Art therapy, music therapy, that's not therapeutic horseback riding. That's not thought of as typical classroom activities, but in some situations, it can be a special ed service. So what I myself rely upon as a starting point are the parents. What do you want? And I'm always asking myself two rhetorical questions. What do we have, and what do we need to have to support the parent's position? And what I mean by that, what we have is the record. And that record can be school records, emails, professional reports, school district reports, report cards, work samples. And what we need to have is whatever else is missing. I have had many situations. I don't doubt for a moment that a conversation or a meeting between a teacher or an administrator occurred. I just can't prove it. And that's where the emails that Jane talked about come into play. We can have a timeline. I mentioned work samples. Work samples are a very important way that parents measure progress. The other day, I had a parent for a 6th grade student send me a work sample, a handwriting sample. And she said, "What do you think?" I said, "Well, it's been a while since I've been in 6th grade, probably about 100 years, but it doesn't look to me like it's 6th grade work. It looked more primitive, early grades, maybe 2nd grade, maybe 3rd grade." But that was my subjective opinion. It just did not, it was block printing, and usually we're a little more advanced. And the spelling, there were a lot of spelling errors and letter reversals. I suggested that it should be looked at maybe by a psychologist, an occupational therapist, and we can answer the second question: what do we need to have to show that that's not an appropriate standard for handwriting and spelling for a 6th grade student? So what the Supreme Court and other courts, and Allie talked about the Cadillac versus the Ford, they created a vehicular metaphor that you're not entitled to a Cadillac, but you're entitled to a Ford. And one judge in New Jersey many years ago said that Ford should have an engine that works and a full tank of gas. So it's not just giving you a high price versus a low price automobile as an IEP metaphor, but making sure it works. Because what parents are a very important and reliable source of information, because they see their child over time in multiple settings. In the teachers, the school see a child in one setting, and that's school. So what you're looking for is, a trend, or at least what I'm looking for is a trend analysis. If over time you're starting to see growth and progress against the baseline, whether it's spelling, math, behavior, whatever is being measured, if you're seeing improvement, that's probably progress. If you're not seeing meaningful progress, which is not appropriate progress, that's a concern. Worse, if you're seeing no progress, or even worse than that, regression. And that's where parents, I just had a parent the other day whose 11-year-old son was being corrected by the 7-year-old sister. And I said that probably creates a lot of interesting family dynamics when the younger child is spelling and reading better than the older child. But that's a measure that the parents could say that my younger child is performing better than my older child. It's subjective, but it is a measure. And that's what parents do as parents. They have wisdom, they have experience, they have that intuition about their child. And I always tell parents, if there's that little voice in the back of your head, or that feeling in the pit of your stomach that is ringing like an alarm bell, don't ignore it. There's something going on. And if you can articulate exactly what it is by having a conversation with a teacher, having a PBT meeting, getting a school evaluation, getting an outside evaluation, sometimes you can literally put the finger on the pulse of what your concerns are. Create high expectations. Don't ignore your concerns, your intuition.
Just quickly talking about expectations, we did have a question that said, how do you advise balancing expectations this year, so 2022, given the pandemic and school staffing struggles? My recommendation would be that our expectations should not be diminished because we are suffering from staffing shortages and struggling with the pandemic. Our expectation is always to provide a free, appropriate public education of the highest standard possible. That should not change, whether it's being delivered online or whether it's being delivered in a classroom. That should always be a district's expectation. Obviously, we need to be realistic, given that not all of the providers might be available. They might have to be quarantining, they might be unwell. But as a district and as an educator or educators interacting with children, there should always be the highest expectation of delivery of that education and those related services. What's your thought, Allie?
I agree. I think there has to be some flexibility because of the pandemic that we're in. But I also find that school systems are using COVID somewhat as an excuse. So for lack of services or reducing services or whatever. So I think we really have to be cognizant and certainly aware of the facts. Is your child getting what he needs? Are there services being reduced? Are the appropriate services being provided? It can be such that the delivery of services may change with the with the situation at hand. By delivery, I mean there may be some co-treating between two staff, like this speech and language with the special ed teacher, or the special ed teacher may need to take over some of what the speech and language teacher was doing, if that would be appropriate. Sometimes it is, and sometimes it isn't. So that's that built-in flexibility, the delivery of services, but the expectations, like Jane was talking about, the what is your child, what are the goals, and what does your child need? That should not be reduced. Again, there needs to be collaboration and some understanding, and also some give and take of time limits. If you see that this is going on way too long. I was working with a family and they had a substitute teacher in for the special ed teacher. Well, the substitute teacher was not a special ed teacher and had a provisional license, which means, just starting out. That was going on for months and months. So again, that, we have to look at the duration of any change of services or any change of IEP delivery. So again, flexibility, but you've got to be a little bit assertive in the fact that you're not willing to compromise your child's education.
So this parlays into the other question, Larry and Allie. What do you do if the services are not being provided for your child as laid out and agreed in the IEP?
Well, the answer, I always tell parents in the current IEP, go to page number 11 in the IEP. That's a grid that gives a numerical summary of the special education service hours and related service hours. And that way if you're supposed to have an hour a day, 5 hours per week, a half hour twice a week, you have a numerical summary of what's supposed to be provided. And the school is supposed to have a log that the services were actually provided. So if you know that services are not being provided per the IEP, that's where compensatory services come into play. And you should ask for the hours to be replaced, especially at the present time and during the past year or so when either schools were closed and there was remote learning or there was hybrid learning, or right now we're hearing about shortages of staff, substitute teachers providing services, not certified special ed teachers or speech and language pathologists, other people who have the licenses and certifications. So if you know how to calculate how much time was not provided, starting with page 11 of the IEP, ask the school district how, when, and where are they going to make up that lost time, those service hours. Ultimately, if you have to, you could file what's called a CRP complaint, which stands for the Complaint Resolution Procedures, with the State Department of Education. It's not a request for a due process hearing, it's a request for an investigation. And the request involves allegations that the IEP as written is not being delivered. My child was supposed to have 10 hours of services per week. I've calculated 7 hours, and the school will not make up those 3 hours. Please investigate. This is information that's available on the State Department of Education website, Complaint Resolution Procedures, ct.gov is the state website. That's my response.
This is a very straightforward answer, I think, Allie. Is an IEP necessary for homeschoolers, and what services, if somebody chooses to homeschool their child, are they still eligible for provisions from the local district?
So if you choose to homeschool your child, which is voluntary, you no longer have an IEP. You are completely separate from the school. So there is no IEP, and you have given permission basically to educate your child yourself without any supports or services from the public school district. That's my understanding.
That's a correct understanding. Unfortunately, that's the way it is in Connecticut. Other states sometimes have services for homeschool children. Connecticut does not.
And I would just recommend to parents that have taken that option and choose to homeschool to still connect and reach out to private practitioners in your area. Some of them do accept insurance. They will complete evaluations. They might come into your home, or you might have opportunities to go to do it remotely. But at that point, if you feel your child needs a particular related service, you might have to explore that independently with private organizations and therapists.
We had one question about mask mandates. Apparently, the child is unable to wear a mask in school. And this is one of the newer developments. On December 31st, 2021, New Year's Eve, there was a joint memorandum from the State Department of Public Health and the State Department of Education. This should be available on the ct.gov, either the Department of Public Health or the Department of Education website. And one of the questions was, can school districts, do school districts have to enforce universal masking? The answer is yes, but then there's a however. Schools must allow for appropriate exemptions to allow for those individuals who cannot consistently and correctly wear a mask due to medical, developmental, or other appropriate reasons. So, so the general rule is everybody wears a mask, and then there are exceptions for medical, developmental, or other appropriate reasons.
How would, this is kind of a back and forth to both of you, how would you and a school district together determine who would qualify for an out-of-district placement?
Well, that's often what I get involved with as an attorney. As was stated before, the legal standard is a free, appropriate public education. And when there's a denial of a free, appropriate public education because the goals and objectives are not being mastered, the child is not making meaningful educational progress, worse, the child is regressing, often parents and sometimes school districts as well start to see if there's an approved private special education school that could meet the child's needs. It might have more structure, it might have a smaller teacher-student ratio, it might have some specialized supports, therapeutic supports, supports for children with learning disabilities, autism, language communication issues, behavioral issues. And that often starts with a PPT discussion. Parents or the school district saying, we're not able to provide a free, appropriate public education for your child, or the parents are saying, in their own words, you're not meeting my child's needs. If there's a consensus opinion, we usually start with a referral to approved private special ed schools. And what a referral is simply a consent form. It's not a commitment by the parents or the school district to make an out-of-district placement. And that allows the school district, with the parents' permission, to provide records and other information to a potential private special ed school. If the school is interested in meeting the child, speaking to the parents, they will continue with the application intake process. And eventually, most private schools would like to meet the student a day or 2 or 3 at the school, private school. And if we all agree to make a PPT placement at the private special ed school, that's how the process will work. The flip side of that is when the school denies a parent's request for an out-of-district placement. Usually parents, in my practice of law, have evaluation reports or other information to support their request for an out-of-district placement. And if that information does not convince the entire PPT to make a placement, parents have the option of pursuing their procedural safeguards, which could be mediation or a due process hearing. Most cases in Connecticut, about 95% of the time, are settled because the parents and the school district find a middle ground between what the parents want and what the school is offering, and then they move on. So tuition reimbursement, mileage, other costs could be part and parcel of the request for an out-of-district placement, because typically school districts do not provide transportation to a private special ed school. So we do have a regulation in Connecticut that allows the IRS mileage rate, which is now 58.5 cents per mile, to be used as a reference point to discuss a mileage reimbursement. So it's always advisable to talk to an experienced advocate, qualified professionals such as a psychologist, clinical psychologist, and or an attorney such as myself to see what your rights are, what the strengths and weaknesses are in a case, what information do we have, what information do we need to have to support a parent's request for an out-of-district placement.
So this is different. We did have a question that we presented before the webinar began that said that somebody was interested in tuition reimbursement from public schools now that they went down the private route for special education. We're assuming that was a unilateral decision by the parents and not a decision made in collaboration with or consent with the district. In that instant, Larry, a parent, what would the parent's rights be with regard to tuition reimbursement?
Well, we have to start with whether or not the school is on notice of the placement. If the parents are making a unilateral placement, they can provide notice at a PPT meeting. I'm rejecting the IEP, it's not appropriate. I'm requesting a placement at the ABC Academy. And if my request is denied, I'd like to be reimbursed for tuition, transportation related costs. That same notice can be provided in writing at least 10 days before the placement date if the parents cannot wait for a PPT meeting. So on the one hand, we have to make sure that the school district is on notice of the placement and the parents' corresponding request for reimbursement. And then as far as the tuition amount, that is subject to negotiation. I have situations where we're dealing with a residential school and the school says we'll pay for the academic or day portion, but not the residential portion. That might be an area to explore in settlement discussions. I have other situations, it's just coming up with a dollar amount in between 0% and 100% that works for both the school district. All of this is designed to ensure that the child's needs are being met. in the private special ed school if they were not being met in the public school. So notice of the placement, creating reasonable expectations, and if necessary, being prepared to litigate the issue of a denial of a free, appropriate public education. Due process hearings are very expensive. They're very time consuming. Ultimately, one side wins, one side loses. And that's why most of the time in Connecticut, cases are settled.
So Allie, this is a question that we were asked as well.
Before
Yes.
you go on to another question, can I just go back to that question about qualifying for out of district placement?
Yes.
I just had something to add. Larry mentioned what we call FAPE, a free appropriate public education, which is a terminology that we use to afford students the right for their education, and all their services and everything on their IEP has to be met in order for the student to have FAPE. Now, that being said, parents come to me very frequently right in the beginning and they say, I want out of the district, I want an out of district placement. You know, that's step one. And I go, whoa, okay, we can get there. But I just want to emphasize it is a process. Out of district placement usually doesn't happen overnight unless there is an extenuating circumstance, and there are those, but usually it is a process. And I always refer the families to what we consider a continuum of services for the school. And that's important to understand. A continuum, for all those visual people, is from one end of the line or the continuum to the other opposite end. And that means that the left-hand side, or one end of the far left of the continuum, is the least restrictive environment where the student is usually placed in all general ed classrooms. Along that continuum to the far right is the most restrictive, which we usually refer to as a special education placement. Sometimes school districts have what we call self-contained classrooms, which is all special education. But along that line, along that continuum, are many services. And what we need to do as families, we need to show that we have gone the route of all of those continuum services to the point where the student's needs are no longer being met, and we are at the far right where, okay, we need a placement. And so that's the process, that continuum. And, you know, very frequently the parents can show that the student is not being successful in their current placement. Well, let's say it's general ed, so they move along the continuum. Many school districts, from my experience, use the goals and objectives on the IEP to determine progress and success. And that's what we look at. If you have a child in special education, you will get IEP recording sheets. Usually they're quarterly. Sometimes if the school's on a trimester, you get them 3 times a year. And those are the sheets that are marked S, M, N, you know, all of those little markings. So as parents, we need to see if your child has achieved his or her goals by the end of the IEP year. If not, then that's a reason to say, you haven't met the expectations for my child. What additional services or what increased services can you provide? So that's where we get into the process of out of district placement. It's to the point where you no longer have the opportunity to provide the services and supports for your child, and you must go to that extreme right, which is out of district. So that's my visual explanation, but I think it helps families understand the process of out of district placement.
And I just want to add to that, goals, and not just that a goal is present, but actually the composition of that goal, how it is written, the language used in the goal, the reference to prompting, fading prompting, the number of trials, how that goal and objective is going to be measured and recorded and by whom is really critical and important. So don't just pay attention to and be satisfied with, oh, I have a goal and objective to address, spelling. You need to really tease that apart and pay attention to the nuances within that goal and that objective. The language used is very critical, and also the way in which it is scaffolded to help the child accomplish and master that particular goal. And look at the percentages. I have been in meetings before where a district has said, oh, if it's 70% successful, they've mastered that goal. My question is, would you consider that appropriate and acceptable for a student that did not have an IEP? To which I've often been told, no, we'd expect them to have 90%. I'm like, well, then it should be the same expectation for a child with an IEP. So pay close attention to the goals and objectives. Don't just be satisfied that there's one there. The nuances of that language is critical and can be used to hold the district accountable to making sure that goal is delivered in the appropriate way for your child, and is scaffolded in an appropriate way for your child too. So that's just a quick thing with regard to goals and objectives. But just quickly, we did have, this is for Allie to lead on to what you were just talking about, Allie. We had a question with regard to special education rights, options and procedures with regard to mental health issues. What's your take on that? I think that mental health issues can capture a broad range of diagnosis. But from what you've described, the diagnosis of the child shouldn't mean that this process we're going through differs, correct?
Well, the diagnosis of the child is definitely important, but the medical field has a different way of diagnosing a child compared to the educational field. There's an educational diagnosis versus a medical diagnosis. For example, I've had clients that have had their child diagnosed medically with autism, but yet when the school evaluates the child is not eligible by their criteria for autism as an eligibility under IDEA. So the mental health procedures, what I would suggest if your child does have any mental health emotional problems, whether it's anxiety, depression, whatever, work in tangent with your medical providers as well as the school, and provide, if possible, a release of information so they can talk, they can collaborate, to make sure that the school and your private provider are in sync with each other, and that the school is doing everything they can according to what your provider is suggesting, what can be appropriate within the school setting. Certainly an IEP does cover emotional issues. It's usually implemented by either the school psychologist, the school social worker, and sometimes at the upper levels, maybe even the guidance counselor. So, excuse me. So the social emotional issues are definitely appropriate targets or goals on the IEP, but usually it takes an evaluation to really target and pinpoint those areas of need.
We had 3 different questions involving the older student, and I didn't want to ignore the older student. One question, how come we're only talking about children with disabilities? My son is 26. The answer to that is, unfortunately, the special education eligibility ends in Connecticut at age 22. And when a child graduates with a regular high school diploma or ages out of the system of special education at age 22, that leads you to the adult service provider system in Connecticut or whatever other state. Connecticut, we have the Department of Mental Health and Addiction Services, the Bureau of Rehabilitation Services, and the Department of Developmental Services. Those are typically the 3 adult service provider agencies after a student exits from special education. The next question was, when should I have a triennial evaluation for a student who's about to exit special education? And the answer, it depends. What are your goals? What are the goals for the child after high school? For example, if they're going to college, colleges, and the child, now a young adult, is going to be requesting accommodations in a college setting, they're going to want to have an evaluation report recommending the accommodations that's less than 3 years old. So the timing of that triennial evaluation might be dictated by whether or not a child is going to college and whether or not they're going to seek accommodations in the college setting. And the last piece is transition planning. So there are no surprises. Starting at age 15, and if a child has autism in Connecticut, starting at age 14, we start the process of transition planning. And that's planning for the student's life after high school by determining interests, preferences, having age-appropriate evaluations to determine how they're going to further their education, how they're going to become competitively employed, and if necessary, to develop independent living skills. So depending on how those questions are answered, are they going to college? Are they going into a vocational training program? Are they going to live independently? Or are they going to work in a supportive employment setting? Or a supported living setting will determine when, how, and what should be evaluated as the student is nearing the end of their eligibility for special education. It's very important for families not to assume that the school is going to do what it's supposed to do. So that's why it's very important to know your rights and know how to access those rights. There are booklets, publications on the State Department of Education website, on school psychology, on transition planning, independent evaluations, learning disabilities, et cetera, et cetera. There's a lot of information. There's a general guide to parents, for parents of children with special education. If you don't have that, read the Parents Guide to Children with Special Education, which I believe was updated about 3 or 4, maybe 5 months ago. So make sure you have the current edition. And this way, an informed parent is the best advocate on a day-to-day basis for their child or young adult. Empowering our young children to become effective self-advocates as young adults is a very important goal, because eventually our children should be growing up, going off to conquer the world, achieve whatever their dreams are, live successful, productive, independent lives because they have received a free, appropriate public education at a critical juncture in their lives. So I notice we're pretty much running out of time, and I don't know if Allie or Jane want to offer some concluding remarks.
I just think that it's critical. We've spoken a lot about communication, just having timely, effective, clear, concise, and documented communication with your districts. Collect data. Data is very important for you to keep a track of the progress your child is making or highlighting areas of concerns that you might have. So communication and data collection, work samples are critical and are pieces that you can take to a PPT meeting and share and show and validate the concerns you have with regard to your child. With regard to the current COVID situation, I think we're all learning in our private and public lives to be more flexible and try to be more tolerant and understanding, but we should do that without lowering our expectations of what is a free, appropriate public education for our children. But it's been a pleasure to be here tonight, to see you again, Allie and Larry, in this new year. And I look forward to more conversations in the future. So thank you so much for joining us. And with regard to JumpStart, which is a recreational part that we do with collaboration with STAR, we have some virtual events coming up. I think we have a painting event coming up fairly soon. So They're free events. You're more than welcome to join, log on and participate. And again, it's about building that sense of community, which is what we're trying to do here through this webinar series. So thank you so much, Larry, for having me here again. And over to you and Allie.
Thank you, Jane. I just want to say thank you for spending your evening with us on this frigid cold night in Connecticut as I started. I get such pleasure out of being able to be part of this panel in discussing our children and young adults' needs. All the participants here have actually made the first step in their advocacy pathway. Just by participating tonight is a tremendous effort and a very important first step in leading your way for your child's and your students' education. So again, thank you for inviting me, Larry and Jane. It gives me a lot of pleasure, and I wish everybody out there the best possible scenario for your own individual student. Good night, and thank you.
I want to thank everybody who's stayed with us this evening. We will continue these conversations and webinars as we move forward. We will have additional experts, consultants, professionals to join our roundtable discussions. We will continue to keep a watchful eye on all special education law related issues. There are some items coming down the road for next year that we will try to have as part of our webinar this year. Our next webinar is scheduled for February 8th at 7 p.m. We have 2 webinars planned for the month of March. The topics have not been finalized, so I don't want to offer the topics for those webinars. If you are enjoying these conversations, please do not hesitate to register in the chat area before you sign off. Send us your questions. Sometimes our webinars are framed around questions that we receive. Most important, I want to thank my daughter, Rachel, for her tremendous effort in putting this together, getting the word out, handling the technology, responding to all of your inquiries, because without all of this behind the scenes work on the part of my daughter, Allie, Jane, and I couldn't do what we have attempted to do tonight, discuss contemporary topics of special education and do our best to answer your question within the allotted time. Please check our Facebook page, website, the Stamford Jewish Community website, and Facebook page for additional information. And thank you all for tuning in. Stay well and healthy. And we look forward to seeing you next month. Thank you and good night.